Mr. Bradley.
Your Honor, my client's been incarcerated since shortly after the alleged incident, since the end of 2014. He's been in well over a year. As to the gang activity accusations and Ms. Matson's allegation, this is sort of an ongoing several-year thing. My client's never, and there's no evidence, my client's ever been involved in any other sort of altercation or present in any altercation. He was there with some friends. He was shot. Any actions he took out that evening were after he was shot and in defense of his life. The state's theory that what it takes to be involved in gang activity, essentially, if you've ever been photographed or are Facebook friends with anybody who's in a gang, you're in a gang. Under Ms. Match's theory, there are not enough jails in this country to hold all the people that would be gang members under her theory.
Well, there's no crime just being a member of a gang. So Matson won't be able to convict anybody of being a member of a gang.
And my client vehemently denies being a member of or taking part in any gang activity. Bond was originally denied in this case some time ago, but here we are. And he was indicted within the 90 days, but towards the end of it. But I believe he subsequently re-indicted. Am I correct, Ms. Matson?
That's correct.
So it is certainly before he was in jail 90 days, well more than 90 days before the indictment that we're currently traveling under. There's been no evidence that he or any person on his behalf has attempted to contact, intimidate, influence, or say hello to any witness in this case. He has no prior felony record. He was 29 years old at the time of this incident. Has never been convicted of a felony. So what the evidence would be that he's some sort of risk to commit other felonies. He has strong family ties to this community, wife, children, parents in this community, no risk of flight paths. That I need his assistance in going through the voluminous discovery in this matter, in this case, in contacting witnesses on his behalf, and I need his assistance in preparing this case for trial. It's still going to be several months from now before we're at trial. I'm going to ask the court to settle up the bond in this case.
All right, Mr. Thank you.
Yes, Your Honor. Thank you, Your Honor. Well, let me begin. I know you're not trying the Wings case today, Your Honor, so I'll try to be brief. But of course, we take exception with most of the facts as outlined and spun by the DA in this case. My client has no criminal history. He was employed at IHOP prior to, unfortunately, being in the wrong place at the wrong time. The only thing, and again, I think it is significant that the activity is caught on videotape, because the only thing my client did was throw a beer bottle indiscriminately and then flee out of the Wings Cafe. The object that he has in his right hand that they want to allege is a gun is a cell phone, and cell phone records will prove that. He was patted down before he came in to Wings Cafe and did not have a gun at that time. So, we first off deny that that he has any gun. He didn't throw a gun after fleeing. He had a cell phone in his hand. He was trying to contact people because of what was going on. He was not, and I think this is significant, was not in Wings Cafe when any of the shooting took place. As soon as he saw that the situation was deteriorating, he left. So he's married. His mother lives here in town. He has 2 kids. He was arrested on the 15th of July, and since that time, he's missed his kids' birthdays, Thanksgiving, Christmas, Halloween. He's got a 2-year-old and a 6-year-old. His wife, Venus Huff, who's here with the children, she works at Head Start. Mr. Taylor was employed. He's got family here. He's got no relation to any of the alleged victims. With respect to this, speaking with a potential witness in this case, all he was doing was referring a message that he was asked to refer to an individual's girlfriend. This is an individual that he knows going back through high school. So we would state the fact that he's got no criminal history. He's got no relation to the alleged victims in this case. He was employed, he's got family, he's has children. He's not a risk for flee of the jurisdiction. His entire family lives here. He's got no means to flee. He's not a risk of committing another felony. He has no criminal record. He's charged with aggravated assault, and again with this gang activity where, as previously mentioned, if you're in the vicinity of someone else who's in a gang, by this standard, you're a gang member. And we would, in terms of any even circumstantial proof that there's relatedness to any type of gang activity, this, for what we understand, and again, the discovery is voluminous in this case, the picture, which is a composite picture, is a collage of pictures that were put together and put on Facebook by somebody else. So we absolutely deny any gang activity. And basically he's been offered a plea to one count of aggravated assault, and of course they're alleging this gang-related activity. So our position, Your Honor, is that he's not a flight risk, he's not a danger to the community, he's not looking to intimidate any witnesses. He's willing to accept any kind of restrictions Your Honor would like to place on him with respect to no contact with any of the alleged witnesses. And, we would ask that a reasonable bond be set. He has a cousin, Jerry Dixon, who's willing to set a property bond for him, and he's got a job waiting on him once he's released.
Judge, I can clarify a couple of things that Mr. Duncan brought up. He does have a criminal history. I think Mr. Taylor needs to inform his client or his attorney that he was arrested in March of 2015 shooting a gun out of a car and being charged with reckless conduct with a weapon, which should have been an aggravated assault, but has pled guilty to it in state court since then. So he does have a criminal history.
Your Honor, I don't know, I'm unaware that he's under any type of probation.
He also has a misdemeanor shoplifting offense out of Riverdale, Georgia, and a no-load misdemeanor marijuana. So he does have criminal history. So.
Well,
None of the significance that we hear about today, Your Honor, and he's not on probation.